Good afternoon. Thank you all for being here today. After researching the provided questions, we are happy to provide our tax advice on the three key issues that were submitted for our review. First of all, that is sovereign wealth fund investment in the United States. Second, transaction contemplated by Mr. Lee with respect to his Korean rental business. And finally, issues related to Huck's pension plan. I will first address sovereign wealth fund investment in the United States and future distributions to investors. Then my colleague Andrii will discuss in detail transaction contemplated by Mr. Lee with respect to his Korean rental business and contributions under Huck's pension plan. We would like to first start with a brief summary of our conclusions before dwelling deeper into each separate issue. So first of all, our advice to sovereign wealth fund is to invest into Lobster LP through a blocker corporation while holding less than 50% in this blocker corp. This will enable the sovereign wealth fund to preserve exemption from withholding tax under Section 892. Second, we would advise Mr. Lee to proceed with his Korean restructuring transaction, but to choose other legal entity than choosing HUESA. Otherwise, the contemplated transaction will ultimately result in taxation of all the building gain he has in his you have in your Korean rental business, after you become a U.S. resident and sell your business. Last but not least, we are generally of the view that contributions under Huck's pension plan are not subject to a substantial risk of forfeiture and should be taxable to Mr. Lee in the year when his employer makes such contributions, but only after Mr. Lee becomes a U.S. resident, of course.
Okay.
So now let's move on to discussion of the sovereign wealth fund investment in the United States. Since the client's goal, so your Mr. Lee's goal here is, So the goal of the sovereign wealth fund in terms of its investment in the United States is to avoid any tax liabilities and tax reporting and filing. To achieve this goal, as we mentioned earlier, our advice is to invest through the blocker corporation while holding less than 50% in that blocker. So let's now describe what Section 892 is. Section 892 of the Code sets two key rules on taxation of foreign governments in the United States. So, on one hand, income from investment is exempt from taxation, and on the other hand, income received from commercial activities is not eligible for such an exemption. So, to achieve the client's goal to avoid this taxation, we advise that sovereign wealth fund invests through blocker. And the blocker should not be, in this case, a controlled commercial entity. This way, the future upstream, which is dividend distributions to investors, will be exempt from 30% withholding tax. We must note here that the blocker corporation will still be liable for 21% in the United States on its allocable share in portfolio companies. But sovereign wealth fund itself will largely avoid taxation of itself in the United States and associated reporting, and even more burdensome taxation than that in the case if it invests through Lobster LP or into portfolio companies directly.
Yes, go ahead.
You said that under Section 892, foreign government isn't taxed on investment income. Isn't this an investment?
The key problem here is that both Lobster LP and portfolio companies are classified as partnerships, and portfolio companies are expected to be engaged in commercial activities within the meaning of Section 892. Thus, though it may seem that sovereign wealth fund has an investment, but since it invests into a partnership, it will itself be considered as engaged in these commercial activities. So all the activities of portfolio companies will ultimately be attributable to sovereign wealth fund. That's why.
So that's why we can't have the 892 entity invest in the partnership directly.
Absolutely.
Okay.
To avoid this attribution. So.
And just to pause on that, so if we did that, and obviously the bigger concern is filing U.S. tax returns. The sovereign wealth fund doesn't want to do that, but would the if if it is deemed to be a commercial enterprise, then it's taxable income to the sovereign wealth fund. So if we invest it directly, I realize it's a commercial activity, so it would be taxable to the, even if you try to set up an 892, it just isn't eligible for the benefits there and makes it taxable on that income.
In case if sovereign wealth fund invests directly.
Invest directly, correct? Yeah.
Yes,
Okay.
in this case, as a partner in Lobster LP and in portfolio companies, sovereign wealth fund will be taxable on its allocable share under Section 704, and it will be
And you
subject
have to file a tax return reporting it as well.
Yes, and the taxation will be quite heavy and burdensome. So that would be 21% on its share in a partnership interest. On top of that, we potentially consider 30% of branch profits tax as it's a foreign corporation engaged in commercial activities in the U.S. So
we come back to your recommendation, which was to form this blocker. And then we get the 21%, certainly the leakage at the blocker corporation, but then you had come back to this no withholding tax under 892. Now, one thing I wanted to hit on the diagram here is you say it's got to be less than 50%. Who are these individuals over here on the side, these other shareholders in the blocker?
any unrelated parties that would potentially be interested in this investment.
But we're going to be concerned here around control because we're thinking about making a significant investment. So can we have any kind of like a syndicate or something like this where we have some obviously they're going to be third parties, but we have some sort of an arrangement in terms of how the investment directions are taken?
Unfortunately, I would say no. Under Section 892, a foreign government to stay eligible for the exemption must hold less than 50% by weight or value and should not otherwise exercise effective control over the entity.
Okay.
Potentially, an option would be like to have a little bit less than 50%, but then many other smaller stockholders, so that
This would be the
That's a
largest
syndicate idea. That
Yeah,
she's-
the largest minority shareholder would
Yeah.
effectively have control,
Yeah.
even though. it'd be
But
less.
in this scenario, there will still be, as a remote risk, that sovereign wealth fund will be deemed to have effective control. So, partially, we need to understand that it's about weighting and balancing what is more important: securing by 100% the tax exemption, or retaining this control.
Okay, that's helpful.
So I do believe we discussed why it is crucial to hold less than 50% in a block or corporation to avoid this commercial entity
Yeah, that's
status.
helpful. Right.
Now let's move on to the second question, which is the contemplated distributions of U.S. source income to the stockholders. Generally, distributions would be subject to 30% withholding tax under Section 884, unless this tax is mitigated by the applicable tax treaty. However, this rule is subject to few exceptions. One of them is under Section 892. And to enjoy the exemption from withholding tax, only two simple conditions must be met. First of all, before any distributions to investors are made, sovereign wealth fund should procure to the withholding agent Form W8EXP. Essentially, it's a simple form to file, simply notifying about the status of the recipient of income and the jurisdiction where it's incorporated. And this form should be procured before any distributions are made to kind of relieve the withholding agent from its obligation to withhold. And the second condition is that this distribution should be credited directly to the account of controlled entities or sovereign wealth fund itself, so to so-called entities eligible for Section 892 exemption. And as was indicated in the letter, Ms. Sarah has such entities. And our advice here would be to use them to receive any income.
And so the bookkeeping is really important. It has to go. Okay,
Absolutely.
that's helpful.
It's as minimal as we can go in terms of reporting and bookkeeping, but it's important. If there are no further questions, I would like to pass the word to my colleague Andrii.
Yeah, thank you, Margot. With regard to a potential sale of a Korean business by Mr. Lee. So before I dive into technical issues here, I believe it's important to talk about the context of the larger issue here. And this is what Mr. Lee should do now in order to reduce the U.S. tax on a potential sale of Korean business in future. And to achieve this goal, we understand that Mr. Lee should undertake the following structure. Firstly, Mr. Lee should incorporate a Korean entity and to transfer his undivided interest in rental property to this Korean entity. Secondly, Mr. Lee should file IRS Form 8832 to make the check-the-box election in order to treat this Korean entity as a disregarded entity. And it is important to make these steps before Mr. Lee becomes a U.S. tax resident. So, what does occur when Mr. Lee incorporates a Korean entity and makes the check-the-box election? When Mr. Lee sets up a Korean entity, this entity is considered a corporation for U.S. tax purposes, provided that Mr. Lee has limited liability with respect to this Korean entity. And under U.S. check-the-box rules, Mr. Lee has an opportunity to change the classification of this Korean entity, and as a single owner of a Korean entity, Mr. Lee can change classification of Korean entity from a corporation to a disregarded entity. This election has three major U.S. tax implications. Firstly, this Korean entity is deemed to be liquidated, and Mr. Lee is deemed to receive all rental property that Korean entity owned before the deemed liquidation. Secondly, Mr. Lee takes fair market value basis in the rental property that he receives as a result of the deemed liquidation. And thirdly, this election would result in no federal income tax consequences for Mr. Lee, provided that he makes this election before he becomes a U.S. tax resident.
So the timing, we appreciate, I think, the timing point you're making, an excellent one. I guess I have maybe a ministerial question, but we're thinking about using this Chusikozer.
Yeah.
That's okay?
Unfortunately, this is the only type of Korean entity that is not allowed for the check-the-box election under U.S. rules. And if Mr. Lee finds that benefits of making check-the-box election and getting step-up in basis that I will describe a bit later, if these benefits are important for him, Mr. Lee should consider incorporating a Korean entity in other eligible form, but of course this form should provide limited liability for Mr. Lee with regard to this entity. So so in short, it should be other entity if you want to achieve step-up in basis. So what advantages does Mr. Lee have as a result of this check-the-box election? When Mr. Lee becomes a U.S. tax resident, he is required to pay U.S. tax on his worldwide income, including income on the sale of his Korean rental business. Specifically, he will be required to pay the tax on the gain. And in this situation, the gain will be computed as a consideration that Mr. Lee realizes from the sale minus Mr. Lee's basis in the rental property.
And if I have to pay tax in Korea, because this is real property in Korea, or a company that owns real property in Korea, does that factor into the U.S. tax considerations at all?
If we proceed with the option where Mr. Lee makes check-the-box election and achieves step-up in basis, there should be no taxable gain in the U.S.
Okay.
Yeah, so I do not see the potential here to credit this Korean tax, but we will need to double-check it if it is a eligible tax for foreign tax credit and whether we can carry forward it. Okay. But in this scenario, it is not really important because there is no taxable gain.
No U.S. tax, right?
Yeah.
Assuming this plan works.
And if Mr. Lee decides to proceed with this option and not to incorporate a Chusikozer.
Yeah.
And why we believe there is no taxable gain here, because the gain will be computed as a difference between consideration and basis.
Yeah.
And as a result of the check the box election, Mr. Lee's basis in the rental property is fair market value as of the effective date of the check the box election. And and it's reasonable to assume that Mr. Lee will make the sale for the same price, because according to the recent appraisal, the price for this property should remain, should not significantly change in the next 10 years. So the basis should be equal to the price for which he makes the sale.
And from the, Tom asked about the timing questions, because I got to figure out when I want to move to the United States, and obviously these are important considerations if I can avoid tax on $10 million in gain. But does this all have to be done in different years or the same tax year? So should I try to get the property into this entity and go through these steps that you're describing the year before I move to the United States, or can it be all in the same year as long as the contribution and the check the box election is before I move? Is there any further thoughts on timing? Because that's really important to me, when I can move and when I should move.
Thank you for the question. The exact timing will depend on the basis, how you move into the U.S. and when you become a U.S. tax resident.
Okay.
I would say that the safe approach will be maybe to make all the steps in one tax year and move in the another tax year. But if you want to do this in the same tax year, we need to track carefully when is the moment when you become a U.S. tax resident, and when is the moment when you make the check the box election, and when this check the box election is effective. And this check the box election should be effective before you become a U.S. tax resident. There is a potential to make election with retroactive effect of up to 75 days prior you make election. So it will depend largely on when is your first day when you are U.S. tax resident.
Okay. But if it's, oh, go ahead.
No, I was just wondering, so what effective date would you put on the election?
This effective date should be before Mr. Lee becomes a U.S. tax resident.
And does it matter, like, how it compares to when the Korean entity is set up and it gets the rental property, or no?
From the timeline perspective, it is important to incorporate entity, transfer assets to the entity. Then for check the box election purposes, it is important to make this entity relevant for U.S. tax purposes. The common technique for making the entity relevant is to open a bank account in the U.S. to make it relevant for information and tax purposes in the U.S. And after the entity is relevant, Mr. Lee should make the check the box election that is effective after the entity is relevant.
And owns the property too? I can't just do this all and then contribute the property after?
No, it's important firstly to contribute property, make the entity relevant, and only then check the box election, because in this case you will trigger these deemed transactions that allow you to obtain a step-up in basis.
Got it.
But if you do not do it in the same
The entity's
order,
got to own the property to get the step-up in basis that it owns.
yeah.
Okay.
Did I answer your question?
Yes, thank you.
Okay. And so the important procedural issues here is that Chusi Kwesa is not an eligible entity, and if you want to get step-up in basis, you should incorporate it in another form, and that this entity should be relevant before you make the check the box election. And yes, as I said, in this scenario there should be no taxable gain. Of course, assuming that the market value of the property does not change, but even if the value of the property appreciates, Mr. Lee will be taxable only on the amount of appreciation, because built-in gain is protected by step-up in basis as a result of the check the box election. And this scenario is better because Mr. Lee does not have taxable gain on the transaction.
So do we have to get an appraisal for the property then? You said a step up to fair market value, but there's not going to be a sale because we're just going to contribute to the entity. But we'll need to know at the time of the check the box election what the value is on that specific date for the real property. Do I understand that correctly?
Yeah, I do.
Somebody's going to have to assign that value to it.
You can get this appraisal, but we were provided with the fact that there is already an appraisal, and this appraisal says that the value of the property should not change during the 10-year period.
But just say we're a couple of years down the road, and the property gets sold into the market, and a client files a tax return, shows zero gain. And the IRS comes in and says, "What's your basis?" I guess that's the point you're getting.
Yeah, there'll have to be some documentation of that.
Are we confident that the appraisal we have is enough? I mean, it's a pretty big number.
Yeah.
I don't even know if the IRS audits people anymore, but
I got your point. I think it will be better to make this appraisal as of the effective date of the check the box election to protect this new basis by the appraisal.
yeah.
Got it. Okay.
All right. Thanks.
Okay, if you don't have any other questions with regard to the sale, I will move to the next question about the U.S. tax implications for Mr. Lee arising from the employer's contributions to Huck's pension plan. Based on the information provided so far, we understand that the employer's contributions should be taxable to Mr. Lee in the years when these contributions are made. However, there are some issues that require additional analysis of information about Mr. Lee's employment and about the terms of Huck's pension plan. And depending on the results of this analysis, Mr. Lee could potentially benefit from the tax deferral on the contributions to this pension plan, depending on Mr. Lee's goals. We were provided with the information that this pension plan is a non-exempt employees trust for the purposes of Section 402B, and Mr. Lee's interest in pension plan is non-transferable. Taxation of employers' contributions to this type of pension plan depends on whether Mr. Lee has a substantial risk of forfeiture with regard to contributions to pension plan. If there is no substantial risk of forfeiture, the employer's contributions are taxable to Mr. Lee in the years when contributed. But if there is a substantial risk of forfeiture, the tax implications for Mr. Lee with regard to pension plan are generally deferred until the moment when Mr. Lee receives distributions from pension plan. And we analyzed provisions of Huck's pension plan, and the term that raises the issue of a substantial risk of forfeiture is that under Huck's pension plan, Chief Executive Director of Huck's can make a determination that Mr. Lee defrauded the organization or committed a serious misconduct, and in this case, the administrator of the plan may apply any funds from Mr. Lee's account against Mr. Lee's liability towards Huck's. The Treasury regulations make a presumption that a return of property to the employer as a result of the dismissal for cause or as a result of committing a crime is not a type of restriction that causes a substantial risk of forfeiture, and generally following the Treasury regulations position, contributions to Huck's pension plan should be taxable to Mr. Lee in years when contributed. But
so can I just hop into that? Because you use the word presumption. So is that the general rule and there's exceptions? Do you see there any wiggle room there? On this?
If my employer knows me to be a very untrustworthy employee that might defraud them, can they just flip that assumption so that somehow?
Is that? I mean, I guess is there any wiggle room? Can we? I'm getting from you. You say this doesn't seem like it's a substantial risk of forfeiture, but
yes, and this is actually what I wanted to discuss. And if Mr. Lee wants to achieve it, we will need to perform additional analysis that this power of director of Hawks to determine that you committed a serious misconduct and withhold funds from your pension account seems too discretionary, at least because the pension plan does not define what is a serious misconduct. So it's too discretionary for a director. And generally, the Treasury regulations say that this substantial risk of forfeiture is a facts and circumstances case. So if we, for example, determine that a serious misconduct is a too discretionary term and it covers a lot of potential violations, we can take a position that you have a substantial risk of forfeiture. And there is no specific support in regulations for taking this position, but for example, in Austin case, the tax court took position that the terms of regulations about what raises a substantial risk of forfeiture should be interpreted narrowly from the perspective of how remote is the event that causes, for example, return of property to the employee and that triggers a substantial risk of forfeiture.
Can I try to cut through that a little bit? What does the Austin case hold? Is it sort of taxpayer friendly or taxpayer adverse?
It's taxpayer friendly. It's this case is about whether a substantial risk of forfeiture exists, where the employer needs to return property. The employee needs to return property to employer if he is dismissed for cause, but cause means a very broad case of events.
In that case, they did find, to Tom's question, a substantial risk of forfeiture in that particular case.
Yes. So in that case, tax court said that substantial risk of forfeiture exists if the...
So I want to make sure I understand you say we can take a position. Is your position contrary to the regulations and in favor of the Austin case, or do you think your view is consistent with the regulations or contrary to the regulations?
To answer this question, we need to analyze what is a serious misconduct for the purposes of Hawks pension plan, what are the terms of employment agreement of Mr. Lee with the organization. If a serious misconduct is a too broad notion that covers events other than, for example, crimes or offenses, there's a potential to take position.
And just a small point to add, so under this Treasury Regulation 183-3, facts and circumstances analysis, and for example, employers' previous practice, for example, if Hawks constantly dismisses or denies the benefits that are generally granted to employees under this pension plan, that would be like a strong reason to claim that it's subject to substantial risk of forfeiture.
I see. So let's just say that Hugs, if you're late, if you're not at your desk 5 days a week, that's serious misconduct.
Yeah. For example, those are being late to work for 15, 20 minutes.
Yeah, thank you.
Okay, so I think we're just about out of time. Bill?
So I was just wondering, I mean, if you were going to file this tax return, what position should Mr. Lee take?
If we do not conduct additional analysis, I think the safe approach would be to say that these contributions are taxable to Mr. Lee in the years when contributions are made. But if Mr. Lee wants to take opportunity and potentially defer tax implications, so we need to conduct additional analysis.
Well, picking up on the point, your excellent timing point on the real estate, could we ask the pension fund to maybe prepay, before Mr. Lee goes to the U.S., prepay 2 or 3 years worth of contributions and do that now before he goes to the U.S.? Does that work?
Generally, if Hawks make these contributions before Mr. Lee becomes a U.S. tax resident, there should be no U.S. tax implications on these contributions. But I think we will need to analyze this from the perspective of step transactions, substance over form, whether it complies with this.
Yeah, no, that's good.
That's done only for tax reasons, but okay.
Great.
All right.
Just to sum up, we wanted to provide a brief summary that our advice to Sovereign Wealth Fund is to invest through the blocker corporation while holding less than 50% in the blocker, and that all funds should be credited to controlled entities of a sovereign wealth fund. Also, our advice to Mr. Lee is to proceed with a contemplated transaction, but with another legal entity than Juicy Huesa. And last but not least, we will be happy to assist Mr. Lee in further analyzing his plan and potentially delay taxation until the time that he retires. He will be a lower tax bracket taxpayer, but we will need more information to that end. Thank you.
Great, thank you.
Thank you.